In our second episode, we sit down with George Lim, Senior Counsel and Chairman of the Singapore International Mediation Centre. Drawing from his vast experience as a mediator, we will look at the intricacies of negotiation techniques, strategies, and cultural nuances from a mediation perspective.
Hi everybody, welcome to another episode of Maxwell En-Route, and we are in Season 2, which is about negotiation. And today we're very privileged to have with us George Lim, Senior Counsel. George is a mediator who has been really a key part of our mediation landscape in Singapore over the last few decades. He was a past president of the bar. He was one of the founding directors of the Singapore Mediation Centre, and he is currently the chairman of the Singapore International Mediation Centre. And he's here to talk a bit more about negotiation and the aspects of it that really are critical to his role as a mediator. So thank you, George, for joining us today.
Well, thank you, Julian. Good morning to your listeners. I'm very pleased to be here.
Thanks, George. I just want to start by saying people think that lawyers, are there to fight and to win battles. So what led you to go into the route where you wanted to talk and to negotiate and to find ways to compromise and do that? At which point did your career begin to go to where you are now?
Okay, so I started off as a litigator. I mean, I've been in practice for 42 years now. And I think when we were in law school and when we went into pupillage, into the firms, litigation was the route.
Yeah.
Okay, there was no formal mediation introduced in Singapore at that time. I think even arbitration was like something not talked about really. So I began my career in a large firm, learning the ropes as a litigator. And so winning was the game.
Yep.
That was the end point. And it's, for a lawyer, and I think many of your listeners are lawyers, are litigators, the adrenaline flow, right? When you win a case, but you feel you've done justice for your clients. Mm-hmm. But, in 1996, our former Attorney General, who became Chief Justice, Chan Sek Keong, called for the setting up of a Singapore Mediation Centre.
Right.
I was then Vice President of the Bar. I was co-opted into the Pro Tem Committee. In Singapore, we say you're arrowed. Okay. I didn't know anything about mediation.
Really?
So I decided to educate myself.
Okay.
So I went to London, did my training. Later, I went to Harvard. But then I found that, look, there are different ways to skin a cat.
Right.
Okay, so fighting is one way, but through dialogue, through creative options and solutions, that's a different way. Mm-hmm. And I thought, hey, this is something which might benefit parties,
sure,
benefit clients. In the old days, without formal mediation, we lawyers used to negotiate in the bar room
right.
over a cup of coffee.
Right, yeah.
We would sit down, and I dare say, even in my own practice, 70% of my cases are resolved through talking and through coffee. Mm-hmm. And you're trying to find fair outcomes for your clients.
Sure.
Right? Not every case you will win.
Sure.
If the case is iffy, it's better to try and resolve it for your clients.
Right.
If the case is poor, please do so. So I found that mediation was a different way. And then because of the setting up of the Singapore Mediation Centre, we came back. A group of us got very excited, very thrilled about it. And we started mediating, and I found the benefits. Okay. I mean, I remember doing one case, mother against a son. Very traumatic, very dramatic, a lot of crying. But at the end of the day, when we managed to resolve it, it was so satisfying to see mother and son reconcile in a small way.
Sure.
Yeah, and so that's why I caught the mediation bug.
But I want to touch on something interesting you said here, because on one hand you said that you were already doing some form of negotiating in the bar room as a litigator.
Not just me, a lot of lawyers, most of us were doing that.
But yet you said that you went to London to train and to learn a bit more. So what did you have to add to that existing repertoire of skills that you were already using in the bar room?
So I think that is still useful for lawyers to be able to negotiate directly on behalf of their clients. But I found that when you have a third party neutral, it makes a difference. Okay, because sometimes, we lawyers, our DNA is to fight. And we sometimes believe in our clients so much that it's hard for us to take the middle ground. Or sometimes you don't want to tell your clients, look, hey, your case is not that great after all. But if you have a third party neutral, it adds a different dimension to the negotiation scene.
Okay.
So in a mediation, I think a lot of parties, a lot of clients now find it's useful to have a third party who can facilitate the negotiations and also be like sometimes add some objectivity.
Okay. But that I suppose in a situation where there's a dispute already, the presence of a neutral is helpful because you are basically sort of the person who can calm things down and you can sort of point out, do a bit of reality testing and stuff. But let's say a dispute hasn't arisen yet and parties are just negotiating like, hey, I want to get the best deal before we sign a contract. Are there any skills in there that a lawyer could, sort of add to their toolbox that generally lawyers don't really realize that is kind of missing right now and they should do more in terms of the...
So this is what we call deal making.
Okay.
You don't have to have a dispute arise yet. But in mediation, the key element in a mediation is finding out the interests of the parties.
Right.
Okay. It's the same principle for negotiation.
Okay.
You have certain interests, I have certain interests.
Right.
Okay. In every case, there's always, right? You know that. So if you can help understand the interests of the other party as well as yourself or your clients, that can be used as the basis for an outcome, a good outcome, because what we do in mediation, what we do in negotiation is to find outcomes which match the interests of the parties.
Right. So, but how does a lawyer and a client, in fact, sort of know what the interest of the other side is beyond what they say? I mean, if they say that this is what I want, what can a lawyer do to say, well, that might not be exactly their interest? How does one go about it?
When people say this is what I want, they take positions. So it's positions versus interest. It's slightly different.
Okay.
Positions are demands you make. I want this, I want that, I want money. But sometimes underlying that, there are interests which are broader than the positions you take. So a simple example would be a defamation case, right?
Okay.
You go to court, you want damages.
Right.
All right. But what's the underlying interest?
You want to clear your name.
Reputation.
Yeah.
Right? And if you want to clear your name or address the concern about reputation, there could be many different solutions or outcomes. So for example, apology is the best.
Sure.
I don't need the money. I just want a clarification,
Sure.
a joint statement.
Okay.
So in many cases, we can address the problem by looking at the underlying interests and looking for solutions which match the interest. So it need not just be money. Money could be a small thing, but it actually demonstrates that you want something more.
Okay.
Yeah.
But this sounds very logical, right? That as a person who's representing your client and you're trying to, get to a deal on the other side, whether there's a dispute or whether you're just in the stages of forming a contract, that sounds logical. Why is it that as a lawyer, we still need to help people understand that you need to get to the interests and not the positions? Why is it something that should be, default, should be obvious for a lawyer who's representing a client? But it doesn't seem to be. That's why we're having this conversation at all.
So, unfortunately, this is my personal view, but we do our best in our litigation system, the court process, but the court process is very legalistic.
Okay.
So the outcomes that you can get are based on the law.
I see.
And usually it's quite narrow, right? Okay. It's win or lose, firstly. There's no common ground, middle ground. And it's usually damages or specific performance, but in a very rare case. Whereas in a mediation, and when I start talking with you, for example, Julian, in a mediation, we can opt for middle ground.
Okay.
We can opt for creative options.
Sure.
I've had cases where I don't want to give it to you, but I'll give it to charity. You choose a charity.
I see.
So there could be different creative options which address the interest. And sometimes people say, I want this, but they don't realize the underlying interest sometimes.
Oh, as in the person who states what they want, they themselves don't know their interest.
Yeah. Or they have not really sat down to think about it.
Okay, that's interesting. Have you seen that happen in a case before, where people don't really understand fully their own interests?
Okay, I can tell you, let's say, I'm trying to find a simple case. joint venture partners, all right? People go into an agreement, they start a venture, then they fall out, they terminate the agreement. You go to court, usually one side is suing, you're asking for damages, right? Breach of contract, whatever.
Yep.
But even after you succeed, you're still shareholders in the venture.
Okay.
And what happens after that? You still got to live with each other. It's not the ideal outcome. Whereas in the mediation, what I would ask the parties is, look, let's go beyond all this, the legal case. What's going to happen after that? Okay. And sometimes the parties come and say, look, actually, I think it's better to have a clean break. Okay. Then the mediation is focused on one party buying the other party out at a fair price.
Okay.
We forget about that. Well, we put aside the old dispute about what happened in China or in India, or whether you breached your director's duties or not.
Interesting.
It's a holistic outcome, and looking at the interests of the parties in the long term, commercially. Do you want to spend the next 2 years doing this, fighting in court? Do you want your reputations out there? You may win, you may lose. It may not. It has no guarantee. Whereas in a mediated outcome, you know for certain you are the architects of the settlement, of the solution. And if it comes out, hey, actually, I think it's better we have a clean break. I can use the resources to do something else. That is what I call the real interest for the parties.
Okay, that's interesting.
And that's a good outcome for both sides.
That's great, because I think if I can extract sort of like a learning point from this example, it's the idea that sometimes in our negotiating experiences, again, whether in a dispute scenario or in a contractual scenario, we are very narrowly focused on maybe a very short time horizon and a very narrow set of interests. And that boxes us in. We don't have anywhere to move because, the options you're presenting aren't that good, and the options I'm presenting, you're not very happy with them. But because we both sort of limited ourselves to like maybe the next 2 years in terms of our planning and discussion, and only this particular jurisdiction. But what you're saying is, if you open up the conversation and say, hey, what happens beyond that, and what about not just in this city where we're currently discussing this contract, but what about the other places where you operate and I operate, and is there scope for us to maybe look at adding more to the table when we put all of those into the conversation? And that suddenly changes everyone's view. That's what you're saying, that it begins to look, hey, actually, that I never thought of it that way. If you allowed me to do this with your other, branches in these other places, then now that would be more attractive for me, and I could probably, try to give you something more as well. And so in a way, the way you frame or scope the parameters of the conversation could determine whether you end up in an impasse and a stalemate, or whether you begin to make progress.
That's why for me as a lawyer of so many years, I found that, I respect the court process. I'm a part of it. But I think we also recognize that there are certain constraints, because we decide based on ratio decidendi, you decide based on precedents and the pleadings, right?
Yeah.
Parties are bound by the pleadings.
Right.
Whereas the interest could go beyond that. And many times in the commercial world today, people are talking about other aspects, different aspects.
Sure.
So I don't know whether you have time, but you want to talk about a case which I did in Korea?
Yes, exactly. So actually,
there's a good example. Yeah, go ahead.
Yeah, so I actually was wanting to sort of mention that case, the POSCO case, right? Yeah, which is this big dispute between...
That's my claim to fame. In Korea, at least.
Yeah, in Korea, but in Singapore, you were famous before that. So this is a case where you basically mediated a settlement between a big American fuel cell manufacturer and a Korean energy company, POSCO, which basically went through several arbitrations. Now, here's the thing which I'm intrigued by, because I've heard from you on previous times some of the what I guess one would characterize as the softer touch that you brought to the mediation when you wanted to sort of get parties to not go in with their guns drawn and their swords laid on the table, but to begin to have a slightly different kind of starting point in the room. So I remember you shared some very interesting things you did, if you're at liberty to tell us.
Okay, so I mentioned this case because we can talk about this case because it was reported.
Yeah.
Which is very rare in the mediation world.
Yes, exactly.
Usually mediations are confidential.
Yeah.
But this case was reported in the Global Arbitration Review. Even the settlement agreement was published because of regulatory requirements. Okay, so it was a case which took place in 2021 at the height of COVID between POSCO Energy, which is a huge energy company in Korea. You go to Korea, South Korea, and everybody knows who POSCO is. And an American company, a Californian company called FuelCell Energy. So in short, the Americans had new technology, green energy. It's huge cells, they stack it up and it creates energy. Koreans wanted that technology. They went into a licensing agreement of sorts. Went well in the beginning. But after a couple of years, problems arose. They accused each other of breaches. And the agreement was terminated. Okay, very bad. Went into 5 arbitrations. They were fighting for 4 years, 5 arbitrations and 2 court cases in the US. 1 billion US involved. So it was a huge case. It got to a point after 4 years, I think to the credit of the lawyers, the American lawyer and the Korean lawyer, they decided, let's try mediation for the parties before it's too late. So they approached me. I was fortunate because I knew the Korean lawyer, and the American lawyer agreed. They didn't want an American mediator, they didn't want a Korean mediator. So I think Singapore, we were fortunate. I flew up to Seoul. We set it for 3 days. And this for me is mediation advocacy at work by the lawyers. We did pre-Zooms. When you're a litigator, you say know your judge, right? Here I had to know the parties. I need to know the interests of the parties. So we did a lot of preparation. For me, preparation is really key. But we decided, let's try a different tack. Let's see whether we can fix the problem. So I tell you, over 3 days, we formed small negotiating teams and we just spent time, issue after issue. I said, what went wrong? Can we fix it? Okay. So in the end, we did something which, with respect, judges or arbitrators could not do. We resurrected the agreement. We revived it, and we rewrote the terms. Okay, so this is what I call the creative option. We turn a dispute into a deal, a new deal. This is what you talked about, deal making. And in the end, the Koreans ordered $66 million worth of new technology from the Americans because there was new technology available then. So for me, this was really a good experience. It's like, we did justice to the parties. Instead of fighting and then ending up with just money and a lot of grief, they decided to go into a new deal. Okay? It was perfect. But it was not easy because of the cultural differences, because of the baggage, the background.
So what do you mean by cultural differences? Like how did that play out in this particular case?
Okay,
what
so
cultural
I will
difference?
make some comments, but it's not a generalization. Okay?
Of course.
Because, different cases, different. But generally speaking, and because I've mediated more than 800 disputes, many of them are international, Americans, I would say generally speaking, are more open, more forthright. They will tell you exactly what they want or what they need. And it's in that way you actually can find out the interest of the parties. Easier. Okay. Asian parties.
Hold on.
Okay, hang on.
I'm assuming that the Americans, by behaving that way, there's also an equal expectation that the other side does the same.
Yeah, so that's where you
I'm
need the
transparent,
facilitator.
but I expect you to be transparent as well. Right?
And that's where you had that problem because culturally, this is my own assessment. Part of the reason why it didn't work was cultural difference.
I see.
You didn't understand.
Okay. So go on about the Koreans.
And it's it goes both ways. Koreans are like, Asians, we are a little bit more reserved. I don't say this for everybody, but in many cases which I've come across, you need to spend more time to build trust and rapport before they will tell you exactly what they need or what their interest is.
Okay.
So I understood that and I needed to spend more time understanding and trying to get out the interest from the parties.
Right.
So for me, I became the bridge for them because the Americans were, why can't you tell me exactly what you want or what you need or what can't we just agree now? But the other thing about Korean, Japanese societies, and this is not negative, it's more hierarchical, right? Even Chinese, there are more layers. So you, as a CEO of an American company, maybe you think you can decide, but I need to consult. I've got board members, I've got elders, and you need to give me time to do that.
I see.
So that is something which I could play a part in trying to help parties understand. So I told the Americans, yeah, okay, this is good, but give me time.
I see.
And let me work on it and give them time.
Okay.
So the beauty of it, we had 3 days. So in the evening, I would sit down with the Korean party and say, okay, can you go and take instructions? Can you go and consult? And then the next morning, we come back.
Okay.
And then we'll talk, and then but you got to be more patient and you got to be more respectful in that sense from the Asian point of view.
Right. So do you see that happening, that the Americans were maybe operating on their paradigm about how an American company would do things and getting a bit frustrated with the Koreans?
Happens all the time.
Okay.
But as I said, this is not to throw anything negative on any party.
No, of
this
course.
is how it is.
It's
our
cultural
culture.
differences. Yeah, it is.
Yeah.
It is.
And I think once we understood, we could get that going, and we could get a small negotiating team and understand each other's concerns.
Right.
So this is part of the mediation process where you talk, you clarify, you dialogue, and then you find for creative outcomes.
I see. Okay. No, this is fantastic.
It's very important, and as a mediator, you need to do preparation to understand. So I had pre-Zoom sessions with the parties, and for me, I Google everybody who's in the Zoom. I'm sure they Google me as well, but it's preparing them before the mediation itself, and they need to have confidence and trust in you.
Right. Okay.
At both sides.
Right.
Okay? For the Americans, I think they need to know that you can do the job. If you are not up to the mark, then I think they lose confidence.
Sure.
So that's how they would measure me, at least, I think.
Competence. Competence.
And the beauty of this agreement, as I told you, is we turned a dispute into a deal.
Yep.
And we checked with the lawyers, okay, a year, 2 years after that. Last year we checked, and the agreement's holding well.
Right.
In fact, we had a seminar in Singapore where the 2 lawyers flew in, and we had a special seminar with our mediators here, and we learned so much because of, they could talk about the case because it was reported.
Right.
So the other cultural thing is, we mediators try to be more creative, and I need to get parties to settle down in order to start talking. So I tried to do something different. The mediation was held in August, September. There's Mooncake Festival in Singapore, Mid-Autumn Festival.
Right.
And for your audience, I think some of you may have tried mooncakes here. So I brought up mooncakes, and I brought up Singapore Sri Lankan tea, TWG tea. If you fly SQ, you know what I mean. So I started the mediation by getting the parties to sit down and have mooncakes and tea. It took the Americans by surprise. They came to the mediation thing, they were coming to like a hearing,
right?
all geared up. But here was this guy from Singapore going around pouring tea.
And what was their reaction to that?
I think it was fantastic because they sort of calmed down.
Okay.
And for us Asians, food is so important. The Koreans loved it.
Yeah.
They say it was the best mooncakes they had tasted. So it was, and it's very Asian, right? We eat and we talk, we drink and we talk. And so that set the tone. And that's very important in mediation, to set the tone, the environment for the parties.
What tone specifically were you aiming for?
To see each other as human beings.
Okay. Sit
down, eat, drink. And then I do my introductions and ask people to talk about themselves first.
Okay.
Because I tell people behind every dispute is about people. It's about persons.
Right.
We need to connect.
Right.
We need to try to understand. And let's look at the issues following that. So I had 3 days, so it was fine. We spent 1 hour just sitting down, chatting and then moving on. So there are different ways. I mean, there are different mediators with different styles. But for me, you need to find the icebreaker to diffuse the tension in the room and to get parties to sit down and really talk about the real issues.
So what I'm hearing from you is that you were trying to ensure that parties didn't go in there not seeing each other as humans, but as a problem to solve and an enemy to defeat. Is that a way of describing that you're trying to say, look, hey, we are all trying to do our jobs here, trying to, protect our interests of our clients, but we don't have to be unnecessarily difficult, nasty, and unprofessional, So that was very interesting because I again, like I said, sometimes we don't realize that in a negotiating context, the problem is not what we are offering or what they are offering, but maybe how someone feels they've been treated. Yeah. And if you don't acknowledge that, where you hear sometimes parties say, I felt very betrayed. We've been working together for so many years, and for you to go and do that, I felt that was not right. And so in a way, I know that I'm being a little bit difficult right now in this particular negotiating, situation. But it's because it's driven by a sense of betrayal. It's driven by a sense of disappointment that we were longtime partners and you could do
that colors everything.
Right.
That colors how I look at the dispute. And sometimes in that process, if I can help clarify, you may have thought this,
right?
But actually it was something else. Right? If I, as a mediator, can do that, I change the narrative. Husband and wife, okay? Somebody had an affair, you blame the other party, but maybe you understand what drove that person. So it's the relationship itself that had problems.
Sure.
Okay, if you address that, you might not have got that byproduct.
Right.
I don't know. And if people take some responsibility, maybe it's a matter of degree, all right?
Yeah.
But if you take some responsibility, you change the narrative. And we can change the focus to, okay, you've reached this point, but let's think about the children.
Right.
Which is the common interest. So we look at common ground, common interest.
Right.
And then you start fashioning a new outcome based on that, on the interest of the children, which both husband and wife usually care about.
Yeah, exactly. Yeah.
So we change the narrative. So there's certain skills, and I would encourage lawyers, whoever in the dispute resolution sphere today, to pick up different skills.
Right.
You can be an arbitrator, you can be a counsel in litigation, but pick up different skills because today's world has changed. The landscape has changed. People are using litigation with mediation, arbitration with mediation. In Singapore, almost every case goes for mediation before you go to court. So pick up the different skills. Go for training.
Okay.
Yeah.
No, I love the POSCO case example because I just want to highlight a few things that I feel are really interesting for our listeners from what we just shared. One is the fact that the cultural differences are something which you had to first of all be conscious of. To actively address, to make sure that both sides sort of don't take away the wrong, conclusions from the behavior of the other side. Where if you do that as an American, it's perfectly fine, but as an Asian, that's not, and vice versa. If you do that as an Asian, it's perfectly fine, but as an American, it's not. So these are things which are important as a negotiating, sort of skill to say, look, I need to understand my counterparty. I need to understand why people think or behave the way they are because they're informed by their cultural context and their, the world that they come from. The second one is how you basically said you revived a dead agreement rather than try to say, okay, how much money we're going to take away and we just walk away from it, right? Which is going back to what we said. If you realize that in it, there were mistakes that may have been made. There may have been misunderstandings. There may have been things that were not done to the satisfaction of one or the other side. And it was not really communicated properly. And it solely bred a bit of unhealthy animosity. But if you go back and sort of like unpack some of these things to say, okay, what went wrong here? And what could we do differently? You change the narrative, as you say, right? So that's a very powerful way because it not just opens a path to a solution, but it also in a way addresses some of maybe a sense of unhappiness or dissatisfaction from the way things went in the past, because in a way you're sort of revisiting it but trying to acknowledge that, okay, maybe we could have done this differently or better, and going forward we'll do it. So there's a little bit, I mean, it sounds a bit trite, but there might be a bit of sort of reconciliation and almost a sense of being able to let go of some of the injustices of the past, because at least we acknowledge now that this part went wrong because you did this, but let's move forward. How do we...
Or even agree to disagree.
Yeah.
But at least we look forward.
And we have a chance to air our grievances, whereas in the past we just sort of kept it within ourselves and it added to that whole sense of tension between us. So I think that's another very interesting thing.
You asked me why... I mean, I see the benefits of litigation, arbitration, mediation. But for me, one of the key points in a mediation is, for the litigation process, we look backward. We look at what happened 3 years ago, 5 years ago. We try to reconstruct.
What are your rights? Yeah,
but in a mediation, I try to get the parties to look forward. What's going to happen after this? What type of outcome do you want? Okay, and we can talk about it in a safe environment because it's confidential and it's without prejudice, which is really a huge advantage.
It is.
Okay, you can scold each other, you can make proposals, you can talk to each other. And I tell my parties that I'd rather you say out.
Yeah.
Put the difficult things on the table and let's talk about it rather than we all just hide it somewhere, and then it'll surface again somewhere. So that is the avenue you have, a chance that you have to talk through dialogue, talk through the problems, but look for the solution.
But I get a sense that some lawyers are uncomfortable with having to play that role, that in their minds it's like, I'm a lawyer, I'm trained I'm trained with legal skills and knowledge of the law. I'm here to advise you on the law. I'm here to help you with your strategy. But now you're asking me to take into account people's feelings. That's not really what a lawyer does. Do you feel some lawyers, sort of don't really find that something they're comfortable with doing, and maybe that's why they're not as effective as they could be?
So there is a difference in that we're not here to do counseling or therapy, but we're here really to at least understand and maybe even empathize. Even if you disagree, at least you understand where that party is coming from. And use that as a platform to move to something more constructive and positive. If in the process there's healing, that's good, but you don't need that.
Sure.
I can agree to disagree, but I tell people, settle for yourselves. Okay? If this other outcome, reviving the agreement and going on different terms, is better for me than fighting it through another 2-3 years, then I should act in my interest or my interest of my company.
Sure.
So settle for yourself, and this is where, in the course of a mediation, a good lawyer will be able to advise his or her client, what is your best alternative to this agreement that's on the table. And I tell people, settle only if, what's on the table, the offer, is close to what you would get in court or in arbitration. Or unless you have a different reason for accepting it. Like, I'm 70 years old, I don't want to spend the next 3 years fighting this.
Sure.
I already had one heart attack. Or it will destroy my family.
Right.
Okay, I'm fighting my brother or my sister.
Right.
We have these kind of cases.
Sure. Yeah.
And that to me has got more value than money. Okay?
Fair enough.
Or I will tell, go back to your divorce case. How is your relationship with your daughter, your son going to be affected by this? If you settle, it's so much easier, right? So there is a value to that. So we take all these intangibles sometimes and we put it, and we tell people, consider all the factors. And as I said, a good mediation advocate will be able to advise a client, compare. And that's why before the mediation, you should do that. You should do that preparation with your client and say, what's your goal for the mediation? Don't reach for something you cannot attain. But it should be something which is close to, as I said, or even better than what you get, if you carry on.
Okay. So that's interesting because
it's a different kind of advocacy.
Yeah, but it's interesting because you're saying that the preparation work that a lawyer should do before a mediation or even a negotiation is not about, okay, so this is what the contract says, this is what the law says, these are what sort of preparing yourself with bullets to fight. It should be more like, okay, what are you prepared to walk away with? If they put this on the table, would you sign it? If not, what would it take for you to sign it? How much more should they ask? Whatever. So in a sense, you're saying that the lawyer needs to really sort of get down into the interest of his own client rather than just...
And understand the other party's interest, set goals for the mediation.
Okay.
And have a strategy to achieve that. Okay? What is your... how do you prepare your client for the mediation? Because your client is now going to negotiate with the other party, with you or without you sometimes, okay?
Yep.
But you need to prepare your client. Whereas in the past, in the bar room, I was just negotiating with the lawyer. But in the context of a mediation, the client comes in.
Yep.
And there are things sometimes, when parties start talking, it's quite different. And sometimes it's quite good because they communicate directly.
I mean, they were the original people who were having a business relationship, right?
And as lawyers, either as counsel, if you can help your clients get that best outcome, I think you've done your job. So at the end of the mediation, I say, okay, this was my target. Have I reached it? Or were we close to it? And if we haven't, then we've not succeeded. So there's a different kind of advocacy, as I say. But,
amazing.
But we really try to help the parties and it's for me, it's a good form of justice because, some detractors say, look, mediation, where's the justice, right? You go and you give up this, you give it that. But to me, if the parties come, and this is from one well-known mediator I know, he said this, if the parties come to a settlement agreement themselves, isn't that a form of higher justice?
Yes.
Right. It's their deal.
It was not imposed on them.
Yeah. They do it knowingly, and they know that this, and they live with it.
Yeah.
So they take charge of the problem, and they take ownership of the solution. Yeah.
That's amazing. That's great.
Yeah. And the world needs less conflict. Okay.
Oh, undoubtedly.
So this was the other thing I wanted to just share, that, because I chair the Singapore International Mediation Centre, we've been promoting mediation in China, India, Korea, Japan, Middle East, wherever, in the Americas. And we have found that, it's all over the world, there is a movement towards this.
Right.
It's a phenomenon which cannot be stopped because, let's look at it, okay? I mean, there's so many conflicts in the world.
Yeah.
Court processes, arbitration, we cannot handle all that.
Yeah.
So, to me, mediation is a good way as a form of access to justice for many parties, and it'll come about. So I tell young lawyers, train yourself, be able to, if a party comes to you, a client comes to you, if you are trained in arbitration, litigation, mediation, you are in a better position than the person who's just in a silo.
Well said. Yeah. Well, we are out of time, George. It's been a pleasure, but I always want to end with a slightly more personal question for all our guests. Without giving too much details, is there a case that you've mediated in the past that you're particularly pleased with the outcome of? Without telling any names or details that can identify it, but something that you really felt like, I feel really good that I was able to help this outcome come about.
Okay, there is one case. Do you have time now?
Yes. No, please.
It's a case which I did a few years ago. It was a simple case. It was a personal injury case. Young boy, I think he was about 20 years old, riding motorcycle, turning into the main road. He was not going that fast, okay? On the opposite side, taxi driver who parked his vehicle illegally.
Oh dear.
He went to buy groceries. Truck behind the taxi, tried to overtake the taxi, knocked into the boy.
Oh dear.
Okay. Boy lost his right leg. They were fighting in court over, contributory negligence, how much. And after a year or so, they came for mediation. So we sat down. Boy came with his father. And I usually start by asking parties, would you like to say something? So I asked the boy, and he said, I want to commit suicide. My life is shattered. No girl will marry me. All my plans are gone. Okay, and then his father sat next to him, and I said, sir, would you like to say something? His father said, my wife has cancer, 4th stage. My eldest son is in prison. My life has been prison, hospital. He was a contractor, okay? Not a lot of means. The room was stunned, okay? We just thought we had problems, but this is a real problem. And I thought to myself, as a lawyer, okay, if I had told the judge, Your Honor, his mother has cancer, irrelevant, struck out, right?
Yeah.
His brother is in jail, irrelevant. But I sat down and I thought to myself, isn't that so relevant in this case?
Yep.
The insurer, the representative came from the insurance company. From a file which he was just seeing, he saw this as a family. And the lawyers, we all were talking legal points, and contributing negligence everybody was trying to do a job, but it was so difficult to come to something. We all sat down and said, okay, I told the parties, don't make this boy and his family go through another 1-2 years of court. Okay, let's do something today. We sat down, 1.5 hours, we resolved it.
1.5 hours?
Yeah. Okay. I told the plaintiff's lawyer, don't ask for the moon, be reasonable. The other parties just stretch a bit. We cleared it. Okay. At the end, we sat down. The lawyers told the boys, were giving him advice what to do with the money. Okay, ring fence it, make sure your brother doesn't get hold of it. The loan sharks will get hold of it.
Right.
But it's such a different mood.
Sure.
And we all sat down, the 2 lawyers and I and the insured representative, and I said, look, today we did something useful.
Right.
Okay, we benefited a family.
Yep.
So for me, this is the magic of mediation.
Mm-hmm.
It really you try to understand the concerns, the needs, the interests of the parties, and try to find something which manages it rather than go through a process which we could avoid and be avoided. So that story sticks with me. Because for me, when I do mediations, I mean, not every case is like that.
Of course.
But it helps motivate me because I think for me, if we can be useful, help parties, that's really something to work to.
That is such a beautiful story, George, and I'm happy with the way it turned out. Thanks to the way you approached this. So thank you.
Well, I was only a small part of it.
No, but
setting up the process,
sure,
giving parties a chance to express themselves.
No, but I mean, you're part of the solution, and I think that family definitely benefited from that. So yeah, but that's great. But thank you so much, George, for this. I mean, this has been a great.
No, thank you
chat.
for having me.
Yeah, I'm sure we have a lot of very interesting stuff here for our listeners to unpack as they are going through the podcast. And we hope to have you back here someday with a different topic or more on the same thing. So you're always welcome.
Maybe before you leave, let me put in a good word for Maxwell because. I was here yesterday.
Right.
We were doing a dispute mediation between a government and an investor.
Mm-hmm.
I can't tell you the details.
Of course.
It's not the Singapore government.
Sure.
Parties flew in, and this is they all told me this is a really good venue for parties. I'm not just trying to sell you, but I'm just trying to share that the environment is very important. And thank you, Maxwell, for that.
No, thank you, George. and it's a pleasure to have you with us here today. Yeah. Thank you.